Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
This is Harmon. This is
What did I?
Harmon. This is Harmon.
Oh, that's why I'm. Never mind. Just testing everyone.
The defense steps up asking for more time, 3 to 4 more weeks, and when a lawyer asks for weeks, it means one thing: that you're not ready to face a jury today.
Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
Okay. And will your client waive the formal reading of the indictment?
So
Okay, we're going on all of the counts,
whatever
or
makes
at least,
it hard.
okay,
Whatever
got
gets
it.
us with the judge.
Okay, I got it.
I think we're going to need all of them to get us to it.
Okay, Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic.
The attorney mentions discovery issues in courtroom language that means they still don't have all the evidence they need from the prosecution, and that can completely stall a case.
Device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft June 28th of 2010, and then you were also convicted of the state jail felony offense of theft on June 24th of 2013, and on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There's none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm.
With every excuse, the judge's patience gets thinner. Judges expect preparation, not delays, and this request signals trouble behind the scenes.
Firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Yes,
All right, good luck to you, ma'am. You can go back with the bailiff. Good morning. Are you Randolph Vines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Vines, in cause number 25, DCCR 1154, the state has elected to proceed on count 1 only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive
The defense hints at medication confirmations and missing documents. These little details can make or break how a case moves forward, and the judge is watching closely.
sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one, I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but lead to charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the bailiff.
Your Honor.
That's what I get for not reading it. Give me just a second. I'm going to print these out. They're both MTRPs, and it's just easier to find me. 19. Good morning. Are you Lamone Yeoman Jr.?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Get on. Should have another one coming also. Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct? And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building, and that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2s.
Tension rises as the judge realizes the case isn't ready. Every unanswered question, every missing paper, every delayed file adds pressure to the courtroom.
Synthetic marijuana. And is that true or not true?
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
True.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025, and is that true or not true? Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025, and is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025, and is that true or not true?
Not true.
All right, did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So,
There's a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set, hold on. Anna, can you send me back 23-1556? I just sent it.
That may be the third degree paperwork. I think you may be right.
Yeah. Okay. I think, so 23-1556 is the burglary of a building, but y'all did TDC paperwork. And the other one, yeah. So, those have to be right. So
We can read them.
I'm going to delete both of those.
That's fine, Joe.
I'll just hold this, we'll continue the hearing, I'm not going to go back over everything, we'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did. There was. We got the numbers wrong. We did.
Okay,
I'll have to redo them both.
sorry.
That's my fault.
All right, I'm going to delete both of those. All right, y'all just go have a seat in the jury box and
Finally, the judge steps in, resetting schedules, demanding clarity and taking full control. When the court gets chaotic, the judge shuts it down fast.